Hello everyone. We're here today to discuss search and seizure in the context of reasonableness. Our discussion begins with Section 8 of the Charter, which states that everyone has the right to be secure against unreasonable search and seizure.
Knock, knock.
Section 8 acts as a limitation on whatever powers of search and seizure the government possesses. Section 8 also protects a person's reasonable expectation of privacy. However, this right is not absolute and requires a balancing act by the Crown. The difficulty in determining reasonableness is determining whether the public's interest in being left alone by government must give way to the government or society's interest in intruding on the individual's privacy in order to advance its goals, most notably those goals of law enforcement. The search and seizure element of Section 8 of the Charter is focused on whether the reasonable expectation of privacy has been encroached upon. To quickly summarize the reasonable expectation of privacy in a search and seizure context, it can be broken down simply into two ways. If there is no reasonable expectation of privacy, then no search and seizure issue. However, if there is a reasonable expectation of privacy, then the search and seizure must be reasonable. To shift our discussion of reasonableness, let's now look at the landmark case of Hunter and Southam. This case applies in a criminal and quasi-criminal context and outlines the minimum standards of reasonableness through the Hunter standards, which can be broken down into three elements. The first element is that there must be prior authorization, usually in the form of a warrant. Prior authorization is an attempt to limit subsequent justification of search and seizures by the Crown. As Justice Dixon wrote, the purpose of prior authorization is to provide an opportunity before the event for the conflicting interests of the state and the individual to be assessed. Warrants authorize police to search receptacles within the designated area, such as filing cabinets and cupboards. However, computers are different. If the police find a computer that they believe has relevant information, the police may physically seize the computer, but they would need a separate warrant to search the contents of the computer. The next element of the Hunter standards is that a search is authorized by a neutral arbiter, someone who is capable of acting impartially and is independent of the executive branch of government. This prevents the police from making a decision on their own volition. This independent party makes the decision as to whether the appropriate standard has been met to award a warrant. Warrants are issued by a justice of the peace, a provincial court judge, or a superior court judge. The final element of the Hunter standards are reasonable and probable grounds. Agents of the state need reasonable and probable grounds, established on oath, to believe that a crime has been committed and that the search will reveal evidence of that crime. This is applied via the balancing act, as we discussed earlier. And, as Justice Dixon succinctly stated, when credibly based probability replaces suspicion. In the Hunter case, all of the requirements listed were lacking and the search was deemed unreasonable. These requirements are the default, however, they're not required in every case. This is where departures from Hunter come into play.
So now we're going to talk about the departures from the Hunter standards. There are situations where the standards are stricter, such as electronic communication and wiretaps. There are also situations where the standards are more relaxed, such as police sniffer dogs and searches incidental to arrest. In situations where the standards are more stringent, judges must have the discretion to refuse or add conditions to the Hunter standards as established in Barron. A prominent example of stricter than Hunter standards includes electronic communication. These stricter criteria exist in order to protect third parties. For example, police might have to delete any conversation by third parties or provide notices to the persons being searched of the investigation as per se. Also, police must demonstrate investigative necessity. Now, let's look at the instances where the Hunter standards are relaxed. Categories of relaxed Hunter standards include criminal and regulatory searches. Within the departures in the criminal category, we can break down the departures by the warrant and RPG requirements. These instances include where either a warrant is or isn't needed, or where RPG is or isn't required to be established. These departures are authorized by either common law or statutes. Examples include searches incident to arrest, Crown and Golden, statutory powers to take evidence, breath or blood, in impaired driving situations per Section 254, Sub 3 of the Criminal Code, statutory powers for searches for metadata, which is information related to the transmission of data, Section 492.1 and 492.2 of the Criminal Code, searches incident to detention power per Crown and Mann, sniffer dog searches per Crown and Kang Brown, and demanding roadside screening samples, Section 254, Sub 2 of the Criminal Code. Continuing on with our analysis of exceptions, let's look at regulatory departures to the Hunter standards. In these departures, we have regulatory searches, which are searches authorized via regulations. For example, a health inspection of a restaurant or workplace safety inspection, border control and transportation, and finally, prisons and schools. So now to conclude, where Section 8 of the Charter regarding reasonableness is breached, in essence, when police do not conduct a lawfully reasonable search, a person may apply for exclusion of evidence per Section 24 of the Charter. Our friends in another group will be discussing the topic of exclusion in detail.